Hey everyone, Harry here to talk about Trump's motion to delay things in the 11th Circuit appeal and why it matters. All right, this is the appeal of Judge Eileen Cannon's dismissal of the entire lawsuit based on a finding that Special Counsel Jack Smith was not appointed lawfully because the statutes that the government has pointed to as permitting an attorney general to appoint a lawyer to help out with an investigation don't provide that authority. It's been kind of portrayed as a big constitutional case. It's not. The principle here under the Constitution, yes, is that you need some authority from Congress to appoint Jack Smith because Jack Smith is an inferior officer under the Constitution. And Congress can provide for appointments of such people, or they can be provided for, says the Constitution, by law, and that means Congress has done something, passed a statute that gives the Attorney General authority. Now has it? There are three or four statutes that have been pointed to by the DOJ, but more than that, we're talking about decisions in courts, including the U.S. Supreme Court, dating back 50 years, all of which say, dating back to the Nixon case, yes, this is fine, and you have the Attorney General can appoint someone to help him do investigations, and that's just what under the regulations now the Attorney General has done. Recall the big point in this iteration of special counsels is it's within the DOJ as opposed to quote-unquote independent, which most everyone thought didn't work out very well. All right, so Cannon does a truly outrageous decision, and the Department of Justice quickly moves to appeal this dismissal to the 11th Circuit. There was the side issue here where they did not say in their papers you should recuse her, and I think that makes it, there may be an opportunity to say it later, but there may not be, and in general. And we've just seen this in the case in New York where the DA Bragg said nothing in terms of whether to postpone the sentencing, and Mayor Chun didn't have the ability to say, well, the DA or the prosecutor wants it, and it made it less likely. I think likewise here, unless the DOJ is pushing for a recusal, it makes it less likely, even though there's reason to think that the 11th Circuit would, and the entire sort of court that Cannon is in the community of, would very much welcome her ouster from the case. Anyway, the DOJ appeals. And we already knew, because of the timing of the dismissal, that it meant that by the time the election comes, the case's status is going to still be dismissed, and Trump can proclaim, as he did, for example, in the debate, that it's been dismissed. So Cannon did the big solid there. But now it goes up on appeal, and I think the widespread expectation is it won't stand, that she'll be reversed, and moreover, then the question will be, is she recused? So that's what's happening now, is the DOJ has filed its brief and said this is a really bad decision, reverse. And Trump's is due in a week, and he has moved for a 30-day extension from September 25th to October 25th now is when his brief will be due. And if you begin to do the math, another couple weeks until the DOJ reply is due, then they have to set argument, and then they have to hear the case, and then they have to write an opinion. And that makes it quite likely that no opinion has issued from the 11th Circuit come the inauguration of the next president. And here's the thing. First motions for 30 days extension, they're just granted. They're not going to say anything. What has the Trump team said? They're too busy in the Chutkin case, deep in a SCIF, a secure compartmentalized facility, looking at the papers there to possibly be able to make the deadline in a week, so they need 30 days. Jack Smith's team doesn't oppose because it's just so routinely granted. It would look sort of, stupid and small-minded, petty to oppose it. So it's going to be granted even though that hasn't happened yet. And now just do the math. So the brief will be due now in late October rather than late September. A couple more weeks if Smith team makes it to have their reply brief. It's, the person who's appealing gets a brief, then a response, then a reply brief. Then they set it for oral argument. Then they hear the oral argument. Then they make a decision. That extra month means that we already were past the election. We already were past a point where anything could happen by a court that could influence or inform the American electorate. But now it looks to me like we are past the possibility of a reversal happening before inauguration of the next president. So it is a delay move by Trump that's not set for the election, but you can imagine the kind of angle he's playing. Let's say he wins. He'll be able to just tell the Department of Justice, lose this case, stop bringing it, stand down. But if it had already had an opinion saying that the dismissal by canon was lawless, or, and it could be a really sort of excoriating opinion, and he then says stand down, it looks worse, right? It looks like he's really smothering what would otherwise be a meritorious case. Cannon would have a big black eye that would make it harder for him, perhaps, to elevate her in the future or do whatever he wanted to do to reward her for her loyal service on the bench. And you have to put that in quotation marks because you're not supposed to loyally serve the president who appointed you. So, it's not the biggest thing in the world because we already were at the point where we weren't going to know anything before the election. But you can imagine scenarios now where what would look like a more outrageous order to dump a case would look a little less so because the state of play would be when he does it. If he does it right away after the inauguration, that had been dismissed by the district court anyway. And as opposed to a higher court has reversed that, then it looks much more sort of, politically driven and subjects him to criticism. Of course, all of this, if he's president, everything's secondary, but that's the sort of math if you do it, and why it's not simply a routine 30-day extension motion, though it will be granted and treated as one just because that's how initial motions for a 30-day extension are treated. He'll get it, and there are scenarios where that means a history, at least, or the political context gives him a leg up for there not being any 11th Circuit opinion reversing the really crazy, lawless dismissal by Judge Eileen Cannon. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.